Hello again. This is Attorney Mary Ann Hamisola Adriana CPA, and another discussion na po ni siya in Bisaya. This is number 2 of the topic no nga listed sa BAR 2023 syllabus under the remedial law. This topic is very very short and straightforward, and I based on my experience no sa mga answering of kanang mga exams pag law school and during bar exam, kani siya nga topic is related to political law, and most of the time dito na siya i-ask or dito na siya ipangutana sa political law. But nevertheless, since covered man siya sa syllabus no sa remedial law for bar 2023 at or gyapon na siyang i-discuss. So this is the rule-making power of the Supreme Court. So you can relate this in our previous discussion when we distinguished substantive law and procedural law or remedial law. In the last distinction no na dito, power of the Supreme Court, dili siya pwede maka-promulgate or dili siya pwede makapasa og kanang substantive law. Pero pwede siya mohimo og procedural rules or procedural law. So naa gyud di ay rule making power si Supreme Court. So ang question is, asa man na gagikan nga power nganong naa may right si Supreme Court to promulgate rules or procedural rules. So this power stemmed from the 1987 Constitution of the Philippines, particularly Article 8. So kung hinumdum mo sa ato ang Constitution, kaning si Article 8 talks about judiciary, no? Article 8, Section 5, Paragraph 5 or item number 5 sa section 5 of Article 8. So Section 5 states that the Supreme Court shall have the following powers. So under Section 5, daghan dito gilista no nga powers of the Supreme Court, and fifth nga gilista dito nga powers sa Supreme Court is to promulgate rules. So unsa man ni nga rules, bisag unsa ba nga rules, dili sad. So limited lang pod ani nga mga rules, no? Promulgate rules concerning the, so morning first nga rule nga pwede niya i-promulgate, protection and enforcement of constitutional rights. Sunod, rules on pleading. Sunod, practice. Unsa ni nga practice? Bisag unsa ra nga practice? Practice of law na siya ang pasabot niya, no? And procedure in all courts. The admission to the practice of law. So mao na siyang si Supreme Court na ay authority to promulgate rules kung unsaon pag-conduct sa bar exam or unsa nga requirements ang kailangan i-submit sa mga tao nga ganahan mo take og bar exam. So under na siya sa power ni Supreme Court. So the admission to the practice of law, the integrated bar. So once makapasar na ka sa bar exam, full-fledged na ka, so member na ka sa integrated bar. So mga rules ana pwede sa si Supreme Court mag-promulgate, and legal assistance to the underprivileged. So that is why si Supreme Court pod maka-issue pod siya og mga rules exempting the indigents, no, katong mga pobre kaayo nga dili makabayad og filing fee, na naa siya right nga na-violate, ganahan ta siya mo file og case pero wala siya pang filing fee. So si Supreme Court pwede na siya mo issue og rules exempting them from the payment of filing fees. So legal assistance to the underprivileged. So these are matters, no, that the Supreme Court could promulgate rules about. Okay. So kanira nga mga rules. Pero outside of this, dili sad pwede manghilabot si Supreme Court. So in the case of Echegaray versus the DOJ Secretary, the Supreme Court said that Congress has no more power to repeal, alter, or supplement rules concerning pleading practice and procedure, because as what we have learned in the previous slide, no, under Article 8, Section 5, Paragraph 5 of the 1987 Constitution, exclusive lang sa Supreme Court ang pag-promulgate sa rules concerning pleading practice and procedure. So dili pwede maka-encroach si Congress. Dili siya pwede moingon nga ay ako na lang nang i-repeal ang katong procedural rules nga issue sa Supreme Court. So dili siya pwede manghilabot, okay? Dili pwede manghilabot si Congress, dili siya pwede maka-repeal, alter, or supplement. because such power is such power that was given to it by the 1935 and the 1975 Constitution has already been taken away by the 1987 Constitution. So sa una nga mga Constitution, naapatoy authority si Congress to repeal, alter, and supplement rules concerning pleading practice and procedure, but gitangtang na siya sa 1987 Constitution, and that power no has already been given to the Supreme Court. So muna akong giingon nga most of the time didto na siya ipangutana sa political law nga kanang dapat dili mo encroach ang one department with another department, no? So kung legislative department dili siya pwede manghilabot didto sa judiciary, okay? So didto na siya kasagaran ipangutana sa political law. So, the Supreme Court, based sa Section 5, Paragraph 5 of Article 8, di ba, nakabutang dito, promulgate rules. So, it was clarified in the case of Sarmiento versus Saratan that the power of the Supreme Court to promulgate rules of procedure carries with it the power to amend and suspend the rules of procedure. So, even though ang nakabutang dito sa kanang constitution no nga, promulgate lang, the word promulgate, but it was clarified in this case that the power to promulgate carries with it the power to amend, suspend the rules of procedure in the interest of justice or when compelling reasons may warrant. So, pwede na ay authority gihapon si Supreme Court to suspend the rules nga iyang gi-promulgate, no? Kung feel niya, kung based sa iyang assessment no in the interest of justice, there is compelling reasons nga makapaingon si Supreme Court nga sige ato lang sa aning i-suspend ang application ani nga rules. So again, it was clarified in this case that the power to promulgate carries with it the power to amend and suspend. So that would be all for this topic. We will now proceed to the third topic sa ato bar syllabus on remedial law.